So maybe you can just let me know if the slides are up and if my voice level is fine.
Everything's
Slides
good.
are good, and the voice is good for me.
Okie doke. There's been some very interesting developments in this whole dispute just in the last few days, so things are very timely. I don't want to bore people with the fine legal details, and maybe we can sort of focus on the implications for the world of hockey flowing from this dispute, but some sort of legal analysis is required. I'll try to keep it as straightforward as one can when you're talking about legal questions. It involves the Canadian Hockey League, and I'm sure people online here, many of you probably know a great deal more about the Canadian Hockey League than I do, but just to give you a bit of a background, it's really an umbrella organization involving 52 Canadian teams and 8 American teams in 3 leagues: the Western Hockey League, which is basically from British Columbia to Manitoba; the Ontario Hockey League, as the name suggests, principally in Ontario; and the Quebec Major Junior League, which again principally in Quebec, but also involving teams in Atlantic Canada. These are generally players who are not adults, although some may be. Many of them are high school age, and they're drafted into the league through what's known as a Bantam Draft at typically age 14 or 15. Many, perhaps most of the players, leave home and they stay with the billet family during the season. If they're high school age, they would go to high school. If they're old enough to be in post-secondary education, some may be pursuing post-secondary studies, typically only on a part-time basis if that's so. They sign a standard players agreement, and I'll talk a little bit more about the standard players agreement in a moment, but insofar as the Canadian Hockey League is concerned, what happens in that league is often very important in terms of the National Hockey League, because as you can see here, it is one of the, if not the principal pipeline for development of professional hockey players, as you can see in the last few years. And I just chose the last 3 years as an example, but this sort of trend is pretty consistent over the last many years. A significant number of players are drafted from the Canadian Hockey League, and an even more significant number of players are drafted from the Canadian Hockey League in the early rounds of the NHL draft. And as I'm sure we all know, being a high draft choice is one of the critical markers in terms of determining whether somebody will actually play professional hockey in the National Hockey League, and whether they will have something of a career as a National Hockey League player. As I indicated before, the players who are high school age and even older, they stay with billet families. They are provided with support in that regard. But these agreements provide for many provisions that suggest possibly that the players could be employees of the team. They surrender their name and image rights. The team provides all of the equipment necessary for the players to play. The players can be traded, but notwithstanding that, the players agree that there's no employer-employee relationship. And this is actually a change in the standard players agreement, and I'll get into a bit of the history around that. So from a legal point of view, having agreed that you're not an employee really doesn't have very much consequence. And what courts and tribunals typically look at is the element of the control that's being exercised over the players or over the individual who would be nominally or notionally an employee. So the other factor is to what extent is the notional employer providing the tools and equipment necessary to do the job. So control being exercised over the direction of training, telling the players where they're to be and when they're to be there, controlling their image rights, allowing or authorizing the clubs to trade the players even during the season. Those are all pretty significant factors. And in fact, the players are paid. And at one time, the Standard Players Agreement referred to this payment as a salary, but that is no longer the case. It's simply referred to as a stipend to reimburse the players for expenses. Another thing that's interesting about the, not so much the standard player, well, it's part of the Standard Players Agreement, but it's also part of the agreement between the CHL and the NHL, is that while the player is under contract to a major junior hockey club, they're essentially not permitted to play professional hockey unless they play professional hockey in the NHL if they're an 18-year-old player. And they're not able to do that unless the CHL is paid a sum of $500,000, which basically is thought of as a development fee that is paid to the WHL. So the players have a very restricted ability when they're an 18-year-old. In many jurisdictions, they would be adults. They either play in the NHL or not at all. And in fact, there is a question legally about whether or not that agreement in the Standard Players Agreement and the agreement between the CHL and the NHL is even an agreement that's lawful. There's a concern insofar as the Canadian Competition Act is concerned, and I'll come to that in a moment. The basic argument in these class action lawsuits is that, in fact, the players are employees, and as such, they would then be entitled to the benefits, the minimum benefits of employment standards legislation, such as the minimum wage, overtime pay, statutory holiday pay, vacation pay, compensation upon termination. Typically, these statutes provide for an adjudication by a specialized tribunal. And for example, in British Columbia, it's the Employment Standards Branch and another appeal body called the Employment Standards Tribunal. Other jurisdictions have similar kind of processes. And if these players were considered to be employees, their status would be adjudicated under provincial law, because in Canada, constitutionally, the vast majority of employees, about 90%, fall under provincial regulation rather than federal regulation with respect to employment standards. About the only private sector employees that wouldn't be regulated provincially would be federal bank employees or airline employees, telecommunications employees, but the vast majority would fall under provincial jurisdiction, and that would be the case for major junior hockey league players if, in fact, there is an employment relationship. And that really is the nub of this litigation. I'll just use the BC example. It talks about receiving wages for work. And of course, the work in this case would be playing and training as part of a WHL team or in British Columbia, or an OHL team in Ontario. And an employer is someone who has direction and control over an employee. So that's sort of the key issue. And this led to the class action lawsuits being filed. So essentially, there are three class action lawsuits, one with respect to each of the three leagues that constitute the CHL. So a lawsuit was filed in Alberta against the Canadian WHL teams. And I should just say that the WHL has American teams. The Ontario League has US teams. The Quebec Major Junior League at one time had a couple of US teams, but does not at this time. There was a bit of legal wrangling about what teams would be covered here, and when all the dust settled, it was basically just the Canadian teams that were involved in this litigation. In order for a class action to proceed, an application has to be made to the court to have it certified. And this is often the critical point in this litigation. If the class action isn't certified, then the only way a player could pursue some sort of relief would be to file some sort of individual action. And if you're talking about employment standards, the money involved is relatively modest. I calculated, just generally speaking, looking across the country, and of course the minimum wage varies, but the amount of compensation that a player could expect to receive on a yearly basis if they were considered to be an employee under the Employment Standards Act would be around $10,000. And so we're talking maybe about $300,000 or less in terms of the labor costs associated with a successful action for each CHL team. So to pursue a claim for $10,000 is, or even less, because of course some players wouldn't be playing all the time. You know, if there's no class action, there probably isn't going to be very much in the way of individual actions being brought forward. So the class action allows for these individual actions to be essentially amalgamated. And now we're talking about potentially a serious amount of money when you look at the 60 CHL teams. So all three actions were certified. And one of the interesting things that happened following the certification, I'll come to this in a moment, is, of course, the CHL's position is that these players are not employees and therefore they wouldn't have any liability under the statute. But if they were employees, obviously there was a concern about potential liabilities. And the question of whether or not these players are employees is one that, for the most part, really falls in favor of the employees. There actually has been some prior litigation. These are older cases, but they're quite interesting cases. I was interested to hear the talk about the World Hockey Association, and one of the things that facilitated the growth of the World Hockey Association in the early years was a decision from the Ontario courts involving a player named John Tonelli, and I'm sure some of you are familiar with him. He played in the WHA and then went on to have quite a successful career and a lengthy career in the NHL. So he had actually signed a contract when he was still under contract to the Toronto Marlboros to play professional hockey for the Houston Aeros. And so the Toronto Marlboros sought to have that contract avoided on the basis that he was already under contract to them. And so the question before the court really was whether or not as an infant that contract would be binding on him. And the court ultimately held that it wasn't. And that, of course, opened up the floodgates, so to speak, for underage junior players to sign contracts to play in the World Hockey Association. And many did, including stars like Wayne Gretzky and Mark Messier and Mark Napier and, of course, John Tonelli. But as sort of a sidelight of this case, the court accepted, pardon me? The court accepted that Mr. Tonelli was under a contract of employment with the Marlboros. And in another decision involving the WHL, this was a tax case, and the question of whether or not the player's service was employment for purposes of receiving employment insurance benefits, and whether or not the leagues were obliged to pay contributions under what was then the Employment Insurance Act, now just the insurance, I think it's called the Employment Insurance Act now, actually, still. The court, and this was the Tax Court of Canada, concluded that they, in fact, are players, and their service is compensable employment for purposes of the Employment Insurance Act. So with those decisions in their back pocket, the players had a pretty good argument, potentially, that they were in fact employees, and they would be entitled to be paid all of the statutory benefits that flow under the various employment standard statutes that exist in all the separate jurisdictions where the Canadian Hockey League operates. So one by one, every single jurisdiction in Canada where the CHL operates introduced exemptions into their employment standards regime so that the Canadian Hockey League players would not be eligible for employment standards benefits. And every jurisdiction did this. You can see, though, that it was very much targeted towards major junior hockey. The British Columbia regulation refers specifically to a major junior ice hockey team. The Alberta exemption, subsection 3, refers specifically to the Western Hockey League. And in Ontario, the exemption refers to the major junior ice hockey team. And all three referred to the scholarship program that is available. And so that was maybe thought of as the quid pro quo for exempting players from the Employment Standards Act, because they have this post-secondary scholarship program that would be available, which is a form of compensation that's deferred to the players, but available to be accessed once their Canadian Hockey League career ends, and similar exemptions in all of the other jurisdictions. So that's sort of the background to the litigation. Somewhat surprisingly to me, and maybe to other observers, after an intensive mediation process, a $30 million settlement was reached. And the effect of the settlement was that most players would receive about something less than $5,000. Any player who had signed an NHL contract was excluded from the settlement. About $9 million in legal fees would be paid to class action counsel, and an additional approximately $600,000 would be paid to offset disbursements that had been incurred. The way that a class action settlement works, it's not binding on the class unless and until the settlement is approved by the courts. And most observers, including myself, thought, well, actually, this is a pretty good result in light of the legal regime that's in place. $30 million is not an inconsequential sum. The $4,800 per player may well represent a relatively small fraction of the total amount of compensation that a player might have looked for if they'd played, say, 4 years in the league at maybe $10,000 a year, but it was still something. And, you know, as is the case with virtually any settlement agreement, there was no admission of liability, and there would be a release that would be required. Now, one of the concerns that arose just days before the matter came before the separate courts in Ontario, Alberta, and Quebec to approve the settlement. And in fact, the Ontario justice said that he absolutely was inclined to approve the settlement, but for this last minute objection that came forward. And it related to the actual settlement language, which arguably would have released the players from all claims that might be advanced, not just the claims with respect to compensation under employment standards. In January of 2019, a class action lawsuit was filed in British Columbia on behalf of major junior players with respect to concussions and brain injuries, somewhat similar to class actions that have been filed in the United States with respect to NFL players, which has resulted in a settlement of, I think the number is about $6.5 billion has been set aside for that class action lawsuit. A lawsuit was filed in Ontario with respect to alleged sexual and other bullying and systemic abuse. And a lawsuit has been filed in the Federal Court of Canada with respect to the Competition Act. And this would be the lawsuit that I referred to earlier in regard to the fact that 18-year-old players can either play in the WHL or the NHL, but they don't have an opportunity to play professional hockey in other leagues. And so the question then becomes, is that a restraint of trade under Section 48 of the Competition Act? So the net result of the applications to approve the settlement was the release was thought to be overbroad. And so in Alberta, the lawsuit the settlement was not approved. In Ontario, it was not approved. And in Quebec, it was not approved. And in each and every case, the sticking point seemed to be the scope of the release, that it was overbroad. So the question then becomes, well, where do we stand now? And I know I'm getting towards the end of my time if I haven't already reached it. So here's where I think we're at. In descending order of likelihood, the release could be renegotiated to narrow the scope, and then it could go back before the courts. And the courts have already hinted quite strongly that they would be inclined to approve it if the focus of the release was restricted to the claims that were advanced in the class action lawsuit involving the Employment Standards Act. I suppose it's possible that the refusal to approve decisions could be appealed, or even less likely, the entire settlement process could be blown up and the litigation would just carry on. If I were to bet, I would say there's probably a 90% probability of the first option, that it will be, the release will be narrowed, it'll be brought back before the courts for approval, and it will in fact be approved. Insofar as the medium to longer term is concerned, as matters now stand, current players, of course, don't have a right to pursue a claim under the Employment Standards Act, because in every jurisdiction they've now been exempted. In my mind, there may well be a question about whether or not those exemptions might be removed at some particular point in time. The exemptions that are in place are only with respect to employment standards legislation. Every province has a collective bargaining legislation, and as we all know, in professional hockey, both in the minor leagues, the AHL and the ECHL, and of course in the NHL, there are collective bargaining agreements in place. There are players' associations, and they negotiate terms and conditions of employment. There is nothing in any jurisdiction that would restrict major junior players from forming a players association. And this in fact has happened in the United States with respect to college football players. And they got a big assist from the Steelworkers Union, which is one of the biggest private sector unions in North America. And they have advanced their cause, and there are a number of statutes or bills that are pending in various state legislatures that would dramatically expand the scope of compensation that would be available to college football players. And they're having a relatively significant degree of success in pursuing that agenda. Would a union in Canada take up the cause of major junior hockey players and seek to organize them and pursue collective bargaining? There would be nothing that would prevent that. And I think as well, those rules that the NHL has with the Canadian Hockey League in regarding where major junior eligible players can play, i.e. only in the NHL, I think that's very much open to challenge. And so, of course, that could have significant consequences for that league and its business operations. And I think we're going to be facing some interesting times in the years to come involving, you know, exactly what is the relationship between players in major junior hockey and what are the options that are available to those players in terms of pursuing a professional career outside the NHL when they're still eligible to play in the major junior hockey league. So thank you for your time and attention. If there are any questions, I'd be pleased to try to answer them as best I can. I also want to say I've certainly enjoyed the conference today, and I look forward to the two remaining presentations.
Thanks very much, Ken. We've got a couple of questions. You can see one on the chat there is, will this have a trickle-down effect to Provincial A, Provincial Junior A, Junior B, and Junior C leagues?
That's a very interesting question. I don't know how it operates in most jurisdictions other than British Columbia, but in British Columbia, the British Columbia Hockey League has actually been a pretty good pipeline among the Junior A leagues to the NHL. Those players are not paid. And in fact, this year, some of them are actually paying to play. So it has more of the hallmarks of amateur hockey as opposed to professional hockey. The junior A leagues, certainly in British Columbia, don't have anywhere near the revenue streams that the Canadian Hockey League has. The Canadian Hockey League has a relatively lucrative television contract. Its licensing revenue is not insignificant. And of course, those major junior teams are receiving $500,000 for each player that is signed to an NHL contract. Those provisions don't apply to junior A hockey, at least not in British Columbia. They do have paid attendance. It's typically quite modest. My understanding is virtually all of those teams operate at a loss, which wouldn't be the case for the WHL teams. But, you know, one could say there's not, you know, I mean, one could say that if the WHL players are employees, why aren't the junior A players employees? And of course, that might be enough to kill junior A hockey, just because I think they already operate at a loss, and putting another $300,000 liability on them would, at least in BC, would be, I think that would be hugely problematic, because I don't think they have the revenue streams to absorb that. So that's an interesting question.
The other question that came up on the chat board is when a player ages out and cannot find employment as a hockey player, do they qualify for unemployment insurance or unemployment compensation?
No, they wouldn't typically, because you know, their employment has ended as a result of the expiration of a fixed term employment contract, as opposed